What about applicants who are also student visa holders? Do they need to provide overseas student health cover?
Yes, again a good question. I might read the policy of the department, which is actually not the law. I am reluctant to give my legal opinion based on the policy. I would always suggest anyone as a precaution to obtain a suitable health insurance that suits this visa, because technically speaking, for the visa to be granted, an overseas student health cover is not suitable for this visa. But the department has different policy options which is favorable, but that's not my advice. But I'll just go through what they say.
Before you start, do you
Yes.
mean that they have to have health insurance with a provider in Australia?
Yes. Well, that's a tricky question. In the short answer for everyone to understand, for most people, international students, the requirement is they have to have health insurance. Whether there are reciprocal health arrangements with other countries and whether that will be applicable in Australia is a different topic. But let's stick to the law and say the health insurance is a must, whether it's in Australia or not. That covers your situation in Australia. So the policy says a student visa holder may present evidence of a valid overseas student health cover at the time of the visa application, but it is not acceptable at the time of the decision. So that's scenario one. The scenario two is if the applicant is not a student visa holder, they make their application and the overseas student health cover is not acceptable evidence. So that's critical. So if at the time of the application, if they are not a student visa holder, if they produce the same evidence, it's not acceptable. If the applicants move from the student visa to a bridging visa, when their student visa ceases, the policy says that you must immediately after the expiration apply for the appropriate insurance that's suitable for the 485 visa.
Those are some interesting points, Dinesh, but let's discuss the Australian study requirements for the graduate work stream.
Yes, this can be quite critical and very important as well. So I might read the law and the policy, how it is, so for people can get a good understanding of it. So the clause is 485211 and it says, provides that the primary applicant must have satisfied the Australian study requirement in the period of 6 months immediately before the day the application was made. So the Australian study requirement has the meaning given in regulation. So we go step by step to understand this simple criteria that someone might think Australian study requirement, I've studied and I've met the requirement. No, you have to go into each law, each clause, each regulation to understand. So if you may allow, I can go into that particular regulation.
Yes.
And yeah. All right. So the regulation 1.15, that is 15F1 says, this is how the explanation in the law or the law. A person satisfied the Australian study requirement if the person satisfied the minister that the person has completed one or more degrees, diplomas or trade qualifications for award by an Australian educational institution as a result of a course or courses. Now hear me out. A, that are registered courses. B, and that were completed in the total of at least 16 calendar months.
So there's a time period.
Time period. So that means if you have not done your studies for 16 calendar months, only on that ground only your application can be refused despite you meeting all the rest of the requirements, and there are no exemptions to consider any compassionate or compelling grounds. If you don't have it, you're gone. So that's why it's quite important to understand and go through these requirements. Now the third point, C, that were completed as a result of at least 2 academic years of studies, and D, for which all instructions were conducted in English, and E, the applicant undertook while in Australia as the holder of a visa authorizing the applicant to study. So that's how important it is. Now we discuss these requirements, and under each requirement I'll take an example C, which talks about 2 academic years. Now Emily, I did a check today for you to understand, for our viewers to understand what the meaning of academic year. It is actually defined in another regulation, which is 1.03. And the academic year means a period that is specified by the minister as an academic year in an instrument in writing for this definition. I've checked
Is there an example?
Yes, I've actually checked the federal register of legislative instrument, and so it explains what it means by one academic year, 2 academic years, and 3 academic years. So 2 academic years means 92 weeks of study in short. So what that means is, if you don't meet any of those elements or sub-elements and requirements, you simply wouldn't get this visa.
So does that mean if you've studied for less than 92 weeks that you won't be successful?
I would say so, because that's the law, Emily. That means if you have an exemption for prior learning either in Australia or overseas, it's critical to understand whether that study is overseas. That means you haven't in reality studied 92 weeks of the registered duration. So we have a mechanism to identify and calculate. It's not a legal criteria, but for us to get an understanding and advise clients. So if we won't advise them to lodge an application if we believe that the 92 weeks is not met, and we ask them to redo those studies where they got exempted if they intend to pursue 485 visa after their studies.
We're almost out of time. Do you have any final words or tips for our viewers?
Yes, this is technically not a difficult visa. The catchy part is that if you meet the requirements. But in order for you to identify whether you meet the requirements, you need to go through the law. Doesn't matter what is in the website, what advice was given over the phone by friends, department or agents. At the end of the day, you will not simply get the visa if you don't meet the law, and the delegated powers are exercised by the case officers, so they cannot do anything as well. Doesn't matter how many letters you write to them showing your compassionate or compelling reasons. If those are not applicable criteria, you'll simply be refused, as we've experienced with the client who had a Hong Kong passport, and a client who actually provided English language after lodging the application simply refused. So it's quite important that you follow the law.
Follow the law. Well, thank you for coming on our panel today.
You're welcome.
To catch up on all our past episodes, you can go to our website www.lawhelpaustralia.org, or you can go to YouTube and just search Law Help Australia. If you'd like to participate in the panel or submit an idea for discussion, you can email us at info@lawhelpaustralia.org.